Welcome back to Epsteinland. This is episode 4, How They Made Corruption Legal. Congress passed a law in 2012 to stop insider trading by its own members. They have never prosecuted a single member under it. The fine for the violation is $200. Let that land for a moment. The United States Congress, confronted with evidence that its own members were trading stocks on classified information unavailable to ordinary citizens, passed a law, gave it a serious-sounding name, the Stock Act, and then set the penalty at $200. Not $200,000, not a criminal charge, not expulsion, not even censure. $200. A member of Congress earns $174,000 a year, and that's before any insider trading. This is not an oversight. This is a message. The message is, we will perform at accountability. We will not actually practice it. In this episode, we're going to trace exactly how that message became the law of the land, step by step, Supreme Court decision by Supreme Court decision, until bribery was redefined out of existence and graft became a lifestyle protected by the highest court in the country. Harry Truman once said, "No man can get rich in politics unless he's a crook." He was not making a cynical observation. He was describing a norm, a standard that American democracy once actually enforced. The idea that public office was a public trust, that using it for private enrichment was a crime, that the law applied to the powerful. Truman earned the right to say that. As a senator, he chaired the Senate Special Committee to investigate the National Defense Program, commonly known as the Truman Committee, which rooted out war profiteering and contractor fraud during World War II, saving an estimated $15 billion in taxpayer money. That's $260 billion in today's dollars. He knew what corruption looked like up close, and he knew that the norm he was describing was one that had to be actively enforced or it would collapse. The Supreme Court has spent the last decade systematically dismantling that norm, not in secret, in published opinions, in legal reasoning that was celebrated by the people who benefit from it. Let's start with McDonnell versus United States, 2016. Bob McDonnell was the governor of Virginia. He and his wife received over $175,000 in gifts, loans, luxury items from a businessman named Johnny Williams, a CEO who wanted McDonnell to use his office to promote his company's dietary supplements. The gifts included a Rolex watch, designer clothing, vacation trips, and a $15,000 catering bill for McDonnell's daughter's wedding. McDonnell set up meetings with state health officials. He promoted Williams' products at official events. He made calls on Williams' behalf. A jury convicted him of corruption unanimously. The Supreme Court reversed it unanimously. 9 justices from across the ideological spectrum ruled that what McConnell did not constitute an official act under federal bribery law. Setting up meetings, making calls, hosting events, none of that was official enough to count. The court narrowed the definition of corruption so severely that the only thing that would now qualify as a direct, explicit, documented exchange, you give me this, I will do that specific thing with my official power. A transaction so naked that virtually only a complete idiot would ever leave that kind of evidence. The Rolex was fine. The wedding catering was fine. The vacation was fine. What the court effectively ruled is that luxury gifts to public officials, as long as they are not directly tied to a single specific documented official act, are simply the cost of access, constituent service, networking. Jeffrey Epstein understood this intuitively before the law caught up. Rolexes, jets, island vacations, these were not bribes, they were relationship maintenance. McDonnell made it legal in 2016. The Epstein class had been operating on this understanding for decades. Now they had the Supreme Court's blessing. Then came Snyder versus United States, 2024. James Snyder was the mayor of Portage, Indiana. He steered city truck contracts to a local company. After the contracts were awarded, the company paid Snyder $13,000. Not before, after. So it was a gratuity, not a quid pro quo. A jury convicted him of bribery. He appealed. The case went to the Supreme Court. In a 6-3 decision, the Supreme Court ruled in Snyder's favor. Federal bribery law, the majority held, does not cover gratuities paid after the official act, only explicit advance agreements to do something in exchange for payment. Justice Ketanji Brown Jackson wrote in dissent that the majority's reading creates a roadmap for corruption. Pay the official after the fact. Keep it informal. Never put anything in writing. The law cannot touch you. And only a complete idiot could mess this up. SCOTUS created a how-to guide and handed it to every corrupt official in America. Put McDonnell and Snyder together and you have a nearly complete legal architecture of impunity and immunity. Before the official act, gifts, meals, travel, tickets, tuition, all fine, as long as there's no explicit written agreement. After the official act, gratuities, payments, consulting fees, also fine, as long as they come after. The only thing the law can now reach is a corrupt official stupid enough to say, I will do X if you give me Y, in writing, in advance, with witnesses. Nobody of the Epstein class operates that way. They never have. Which brings us back to Congress. In 2012, revelations emerged that members of Congress had been trading stocks in companies affected by legislation they were writing or information they received in classified briefings. The practice was legal. It was widespread. It was flagrant. Congress passed the Stock Act, Stop Trading on Congressional Knowledge Act. It sounded serious. It had a serious acronym. The president signed it in a ceremony. The penalty for violation? $200. No member of Congress has ever been prosecuted under it. Not one. Members of both parties have made trades with suspicious timing, buying and selling stocks in ways that happen to align remarkably well with non-public information that they had received in their official capacity. The trades were reported. The fines, when they happen at all, are $200. The door remains wide open. Let me also add a note about our sitting Attorney General, Pam Bondi. $25,000 donated from Trump's foundation to her re-election campaign. Illegal, as foundations cannot make political donations. Her office was simultaneously deciding whether to investigate Trump University. They declined. Quelle surprise. The Billionaires Foundation paid a $2,500 fine for a paperwork violation. Say that again. The Billionaires Foundation paid a $2,500 fine for the paperwork violation. The influence was never examined. Under McDonnell, it didn't need to be. I want to be clear about something, because this episode is not a partisan attack. This is not a Democratic problem or a Republican problem. It's a structural problem. Members of both parties have made trades that deserve scrutiny. The system enables both. What has happened is that the people who benefit from a weak Stock Act are the same people who would have to vote to strengthen it. The people who benefit from the McDonnell and Snyder decisions are the same people who appoint the justices who wrote the decisions. This is not a coincidence. This is the system working exactly as designed. And then there is the new frontier, the thing that McDonnell and Snyder made possible that no one was thinking about in 2016, prediction markets. Platforms like Polymarket allow users to bet on the outcomes of anything. Elections, policy decisions, economic events, crises. The idea is that aggregated bets reflect the wisdom of crowds, that prediction markets are more accurate than polls or pundits. Maybe, but here is what they also are. They are dark pools where anonymous megadonors can bet on outcomes they have inside information about, or outcomes they can influence, where someone who knows a regulatory decision before it is announced can place a large anonymous bet and profit from it, where someone who has paid for access to a politician can bet on what that politician is going to do next. Under McDonnell, the access payment was a Rolex. Under the prediction market model, the return on that access is a winning bet placed anonymously on a platform operating outside the reach of financial disclosure laws. Ghirardellis called these platforms everything casinos. That is exactly right. The house always wins, and the house is the Epstein class. McDonnell and Snyder did not just affect governors and mayors. They set the template for how influence operates in America at every level. And now prediction markets have taken that template and digitized it, laundering influence through probabilistic bets rather than direct bribes, turning insider access into anonymous profit, making the corruption invisible, liquid, and legal. This is the operating system, not a conspiracy, a set of legal decisions and financial innovations that, taken together, have made it nearly impossible to prosecute the powerful for enriching themselves through public office. And one more thing, because we cannot discuss the legal architecture of impunity without acknowledging who sits at the top of it. ProPublica's reporting documented years of undisclosed gifts to Supreme Court Justice Clarence Thomas from billionaire Harlan Crow. Real estate transactions, private jet travel, luxury vacations, private school tuition for Thomas's great-nephew, gifts worth hundreds of thousands of dollars, none of them disclosed for years. Under McDonnell, as narrowed by the Supreme Court Thomas himself sits on, none of this constitutes bribery. It is access. It is a relationship. It is the gift economy operating at the highest levels of the American legal system. The Supreme Court has no binding ethics code. Justices are not subject to the same financial disclosure requirements as other federal officials. The people who interpret the law that would govern their own conduct are the same people who decide whether that law applies to them. This is Will Hoyt's law in its purest form. The in-group the law protects but does not bind. The justices who narrowed corruption laws are operating under the protection of the corruption law they narrowed. Imagine if Harry Truman was operating under our new rules. There would have been no Truman Committee. The war profiteers and their co-conspirators would have gone about their business unfettered from accountability. We have now traced the full legal architecture of impunity. Citizens United unleashed the money. McDonnell and Snyder redefined corruption out of existence. The Stock Act performed accountability without actually practicing it. And the prediction markets digitized the gift economy for the 21st century. Every layer of this system was built deliberately. Every decision was celebrated by the people who benefit from it. None of it is hidden. All of it is legal. In our next episode, we are going to do something different. We are going to talk about hope. Not naive hope, evidence-based hope. The historical proof that this system can be challenged, broken, and replaced. From Theodore Roosevelt to Franklin Roosevelt to Lena Khan, from the trust busters of the New Deal to the antitrust revival. And we're going to talk about a political scientist at UC Berkeley who has studied what it actually takes to beat authoritarian politics and what the Democrats keep getting wrong. If this episode resonated with you, please share it, because the corruption we have described today is not theoretical. It is the reason your insulin costs what it costs. It is the reason your town lost its factory. It is the reason the people who caused the 2008 crash kept their bonuses. It is the operating system, and the first step to changing it is being able to name it. I'm Chris Hughes, and I'll see you in episode 5.